6:34, that's our time here on Sky 99.5 FM, and we're diving into the first of our news-making segments for today, Friday, the 26th of May, 2017. On the line with us, with a cup of coffee in hand, having his breakfast alongside us, Martin George, Senior Attorney at Law and member of the Police Service Commission. Good morning to you, Martin George.
Hi, good morning to you, Jessime. Good morning to your panel. Good morning, Dr. Wayne. Good morning, Edison. And good morning, Trinidad and Tobago.
Mr. Carr, actually, shock of shocks, is not with us today. He's on another assignment.
Oh, okay.
Can you believe it? Can you believe it? I feel like a fish out of water this morning.
Yes.
Anyway, what I'm going to do now, I'm going to just refresh everyone's memory with the report that was filed yesterday with regard to this issue, and then we can pull apart some of what has been revealed in the story. Okay?
Sure.
An admittance of blunder for which the Judicial and Legal Services Commission is yet to apologize. That's how the decision to restart each of the 53 parthead matters is being looked upon by one senior counsel.
My position that the members of the JLSC should do the honorable thing has not changed. In fact, the lack of an apology has hardened my position.
Martin Daly, past president of the Law Association, deems it a grave injustice to the accused, some of whom have spent as many as 7 years in state custody.
It is shocking that this release does not contain an apology or a beg pardon. This is a serious injustice that has been done to the people whose cases have to be restarted, particularly those who have not got bail.
In the legal fraternity, some like criminal attorney Kristen Williams, who represents the murder-accused men responsible for a near riot some weeks ago, disagree with the move. He tells CNC3, quote, "The accused men are now at a disadvantage. No one asked whether they can afford legal fees to restart this process with what they deem fitting representation. Many may now have to apply for legal aid, and there's no telling if that department can handle the load." Some other attorneys question whether a loophole has now been created which allows the accused to contend due process was not followed and they deserve some concession. Criminal attorney Wayne Sturge predicts mayhem and judicial review for the recuperation of legal fees expended. Mr. Daly says those discussions are premature.
Well, there's already been discussion on social media about what remedies the accused persons might have. Arguably, they've not received the protection of the law. Arguably, they could say that this is double jeopardy, but I don't want to go down those roads because I think it's far too early to think, to give mature consideration to those things.
And for senior counsel Israel Khan, the decision to restart the cases de novo is long overdue, and mayhem can be avoided by explaining to the accused that they may now benefit from an expedited process.
Well, no, they'll have to explain that what law is being restarted, they will go from day to day or week to week. And if she was any part of matters, it would not have been done so quickly. It would have taken months to be completed. Now, by 3 months, all these matters could be completed.
The attorneys we spoke with all agreed the real issue into the JLSC's appointment of Marcia Ayres Caesar to the High Court should not be overlooked, and someone must be held accountable. Overshi to Arab Ryan, CNC3.
Martin George, we've just had our memories refreshed, and we've heard some interesting commentary from a couple senior counsel on the matter. Israel Khan saying that there's no reason why everything should descend into chaos, but the real burning issue of can the accused men, can they afford, legal representation at this point in time?
Yes, and I think the point that has been made by Senior Counsel Martin Daly is, so valid and germane to the issue, because I think, unfortunately, Jessime, what we are seeing here, it appears to be an absolute lack of the taking of responsibility. It appears that, if you remember in the Watergate crisis,
yes.
President Nixon, he was casting about for everybody else to blame. He would throw everybody under the bus, in an attempt to try to save himself. because he did not want to accept or take responsibility. And it appears that that's the point that Mr. Daly is making, because he says that, look, you don't even see any apology coming here. You don't see any acceptance of, that to say that they were wrong or anything of the sort. And I think that remains central to the issue because, in mature democracies, in developed societies, persons take responsibility for their, actions, and they would do the honorable thing, they would do the right thing, they would offer the mea culpa and say, well, look, we were wrong collectively as a body, as a group, whatever. And, in any civilized society, I don't think you would even have to call upon persons, to step down as Martin Daly has done. They would probably know what is the right thing to do. But unfortunately, I think we are still seen almost as a ruling by edict, that, we have declared or I have declared, that this is going to be the scenario. But the point is, it still does not address the fundamental issues. Nobody is saying even what is the scenario as to what is to happen with Miss Ayres Caesar. Where is she to be placed? Because from what we were told is that she was reinstated as chief magistrate. How does that occur? Is that valid? What's the scenario? No one is admitting wrongdoing, admitting culpability, admitting their errors, and that's the fundamental thing. And it goes from the very start in the sense of the process used for the appointment and whether due diligence was really applied, whether there was thorough scrutiny of the facts which are available to you as a body, or and that I think is the nub of the issue here. Because if you want to restore public trust and confidence in the judiciary, then the public is very well alive to the factual matrix and the scenario here. And if the public does not hear coming, emanating from the judiciary, some sort of, or the JLSC, some sort of apology to say, well, okay, look, let's level with the population. This is the scenario. This is what occurred. Then I don't think you have the basis for even moving forward to say that you are going to restore public trust and confidence, because people are not foolish. It's like, you've done someone wrong, and you don't apologize, and then you say, okay, right, let's forget it and move forward. How does that work? How does that scenario occur or obtain in reality?
Mr. George, morning here again. You answered my initial question about where is Mrs. Ayres in all of this, but you addressed that. So I'm going to put the focus now on the accused. We heard, I think, Senior Counsel Can mention that this might work together for their good in terms of fast tracking. Can you explain that for us? And where is the overriding adjective in all of this?
Well, the thing is, I would prefer if you ask Mr. Khan to explain how that is going to work, because the thing is, as we have seen repeatedly in Trinidad and Tobago, when you talk about fast-tracking things in terms of cases and case management, it never appears to work out that way. Because when you're talking fast-tracking, you're talking, then is it that you're going to tell the attorney who says, well, look, I can't attend today because I have other matters in court. Are you going to say, well, look, if you don't attend, we are going to proceed without you? How is it the attorney's fault when he would have probably done most of the work in that matter already, and because of no fault of him or his client, the matter has to be started over? How do you fast track in such a scenario? How do you fast track in a scenario where an accused person cannot now afford to pay a new attorney or pay his attorney again to do over the matter? Because once you start over a matter de novo, then the attorney has to be paid for the matter again, because he has to go it all over again. Because let me tell you, it's not as simple as that. The same witness can come back and give totally different evidence in a matter. Right. So the attorney has to be prepared for that. He then has to now apply for the transcript of what the previous evidence was to be able to compare it. Now his work is doubled, because he now has to go through that transcript compared to the evidence you're giving now, cross-examine you, not just on the factual matrix, but also on the evidence you gave before. Because if before you said that, look, the men were driving a red car, and now you say it's a blue car, then that's a totally different scenario. So you are talking about it's a minefield, and the simplistic way that this has been presented as if, well, it's you just start over the 53 cases. It's not as simple as that at all. And anyone who is within the bowels of the judicial system and the practice as an attorney at law before the courts knows that. So therefore, it appears to be an underestimation of the chaos that ultimately will result in this scenario, because you are talking about persons who could now file applications. They may be able to file constitutional motions. They may be able to file judicial review applications, because this comes down to nothing but a denial of your fundamental human rights. Your basic constitutional rights are going to be denied one way or the other. And I think persons will be very well entitled to test such matters before the courts.
Now, I saw the report. It says 53 unfinished cases. I think early in the conversation, when this was flagged a few weeks ago, wasn't 53 mentioned? It was something like 20 or something like that?
But this is my point. And my point also is that if it is that the same body can now determine and say, well, we now know it's 53 cases, then when you were doing the interviews, didn't you have the ability to get the information the same way?
Indeed.
This is, and I think that's the point that Mr. Martin Daly is making. He's basically saying, look, hey, don't just come and issue this as a pronouncement when you are not acknowledging the fundamental flaws that must have occurred at the get-go. And there seems to be no willingness to acknowledge that, no willingness to, come out and, say, well, look, hey, mistakes have been made. You look even at the scenario where former Attorney General Anand Ramlogan challenged the composition of the JLSC because it appeared that they were functioning without one member, and then it appears that the response has been, okay, well, we've now appointed a fifth member, so, all right, basically keep quiet. What are you still complaining about? And it's not as simple as that. What happens to the validity or otherwise of decisions which would have been taken while you did not have a fifth member, while you were not properly constituted? I mean, granted, it says that a quorum consists of 3, but there are bigger issues here, because, in other words, the question is, do you have a commission at all if you are not properly constituted? So, separate and apart from the question of a quorum, it goes to your fundamental entitlement and your fundamental, lawful authority as to whether you are properly constituted. And again, you saw the type of approach where, there appears to be no acknowledgement of wrong or no acknowledgement of fault. And instead, the simple reply was, we now have a fifth member, so, let's move on. But it's not as simple as that, because you have to now question, were the decisions taken while you were not properly constituted, were those valid decisions? Can those decisions stand? And these are things that have to be answered. I mean, of course, they unfortunately are hard, difficult, and maybe embarrassing questions. And nobody likes to be faced with those kinds of things. But the point is, to he whom much is given, much is expected of him. So therefore, you have to bear the burden with the benefit.
So
you
then
can't just get the benefit of the position and the power and the authority and not bear the burden of the accountability and responsibility and the transparency required.
I'm just wondering how many of these cases would any of these senior people have to deal with. I'm sure they won't have the headache of having to go through any of these 53 matters themselves.
Well, the thing is, this is at the magisterial level. So the point is, it's the magistracy that is going to have to, be faced with it. So it doesn't even touch the upper echelons of the judiciary. So
and have they even stopped to consider that maybe they didn't need to determine that the cases, be heard again de novo? Could they not have continued on from the point at which they were standing Is there
Well, you
nothing
see,
in our
I
regulations that would allow for that?
Well, I think it's because there appears to be the continued failure to acknowledge the elephant in the room. The elephant in the room is the missteps and mistakes which occurred with the initial appointment of Martha Ayres Caesar, the subsequent resignation, and then saying that she's going to be put back as chief magistrate. I think it's upon mature reflection that persons realize that it can't work that way. It's not so simple. So because they cannot, I think there's a recognition, while they haven't publicly acknowledged that, and that's part of what people are saying now, that there appears to be no acknowledgement of, okay, well, we made a mistake, we made a blunder, we made an error here. There seems to be no acknowledgement of that, and I think it's because of the conundrum within which they find themselves in terms of what do we do with Miss Ayres Caesar, because they could not realistically think that they could put her back as chief magistrate, because you're talking about frustrating the aspirations of other magistrates who may have been aspiring to the post. You're talking the question of the validity of the process. In other words, has that post been advertised? Has she applied for it? Has she been interviewed for it? You have just basically cherry-picked her, and placed her there because you were trying to cover, or maybe rectify a situation that maybe you have been somehow culpable for in the beginning. And I think upon recognition that that is going to create even more of an embarrassing scenario, it looks like they've just, decided, well, look, let's pretend that scenario is not existing. Let's not address it. And let's just simply say we're going to start the matters over de novo. It's not, I tell you, Jessime, if you and Dr. Wayne recall, from the very first conversation we had on this issue several weeks ago, I told you that this is not the beginning. This is not the beginning of the end. That was really just the end of the beginning. Because this is not going away easily. It's not going away simply. This thing needs some fulsome exposition and resolution, and we have not had that yet. Because the point is, it's like you're somebody who may, be suffering from some sort of mental illness, and you want to carry them for treatment. But if there's no acknowledgement that, look, there is an issue here, there is a problem, you can't even begin to treat the problem if there's no acceptance or acknowledgement that, look, there's an issue. And I think that's where we are all stuck, because we are not seeing that acknowledgement, that public mea culpa to say, well, look, yes, this is what occurred, we were wrong, and we now want to try to take the steps to move forward. What you're hearing is, okay, all right, could you all please stop talking about that and let's just move forward? And I don't think the public in Trinidad and Tobago in the year 2017 is going to accept that, unfortunately.
No, you keep repeating the we taking ownership. Who should derobe then and put on the proverbial sackcloth and ashes? Yes, is it should it be the CJ or the whole JLSC?
Well, from what I see, Mr. Martin Daly speaks of, I think he identifies both, as
But what would be the implication, Mr. George? What would be the implication?
Well,
I'm listening to all of this and getting a headache.
Yes, because just to remember, as I said, it's like you have a suit, and on the jacket there's a little thread sticking out, and you start pulling at that thread and thinking, well, just pulling it, and that would be the end of it. And the more you pull, the more it unravels.
Yes.
And that's exactly the scenario we are facing here. That's exactly the scenario we are facing here. And I think the more persons dig their heels in, the more hardened the positions become, and the more cataclysmic the result.
So implications. Give us a little sneak peek of a verdict. Implications here. If ownership is taken and they take the humble road, what will be the implication?
Well, the point is you're talking about, a full-blown crisis that is going to be occurring. And, the point is we can only determine what ultimately will happen if we see some sort of action in that regard. But the point is, we haven't yet seen any inclination or indication of that. I know the Law Association is supposed to meet on the 1st of June, which is next Thursday.
Yes.
And they're supposed to, consider some, motions that have been tabled, so I guess we'll have to see how that goes. But, at the end of the day, it really is such a poor reflection of leadership for young persons in Trinidad and Tobago, because if you, as a young person, you see leaders behaving like this and no one stepping forth and standing up and taking responsibility, then what sort of example are you setting? What sort of how then can you sit and pontificate on anybody's matter with any moral authority when the whole nation knows that you yourself have not been taking responsibility at all for your actions?
Wow.
How do you even have the moral authority to rule or lead or govern? And these are questions that cannot be escaped and cannot be avoided. And there comes a time when, as a nation, we have to really hold the feet of our leaders to the fire and say, hey, listen, you have to account, you have to be, responsible for your actions. Otherwise, you really have lost all moral authority to lead.
Indeed.
So in the complexity of all of the issues at hand, Mr. George, what is going to happen with the accused? Who is going to look after the interests of the accused?
Well, I think hopefully they should have their attorneys, or if they can no longer afford their attorneys, they may have to apply for legal aid, and then they will have to look at each individual matter and determine how they're going to treat with it, whether they will go along with the process or whether they will say, look, our clients have been so prejudiced by this turn of events that it really amounts to a denial of their fundamental freedoms and rights, and the basic principles and tenets of natural justice and procedural fairness, and they may then decide that, look, they're challenging these things. So it's a topic that, trust me, is not going to go away easily. This is not the end at all. This is
you keep repeating that statement. It is not the end, and no, every time we think it's going away, it's flaring up again, Mr. George.
That's the point,
and
that's why I said it, because there's no initial acknowledgement or any fundamental acceptance of responsibility, then all you are really doing, you just keep putting plasters and band-aids on top of a cancerous sore without treating the problem itself. So that's why I keep saying it's not going to go away so easily. Unfortunately, I have another
yes, you need to leave. But thank you so much for squeezing us in this morning.
As always.
All right, thank you.
Have a good morning and a great weekend, Trinidad and Tobago.
Thank you, sir.
We've been chatting with Martin George, a senior attorney at law and member of the Police Service Commission. And, I'm listening to what he says, and clearly it's a case of the JLSC and the Chief Justice wearing new clothes, like the Emperor wearing new clothes, and not realizing, that everybody can see everything.
Wow.
And they're not even aware of how exposed and naked they are.
Every time I think this thing is coming to an end as a resolution, we're hearing it flaring up. And I'm saying, can this be compared to what we're seeing happening in the U.S. with this Russian probe right now with the president and the last elections and all of that? Because every day is a new chapter evolving. Something is coming up every day. And they're probing, and we are in dire straits here, because listening to Mr. George, the impact of this, I don't know how the judicial system will function. We don't know how far down the rabbit hole we will go.
Anyway, folks, we're wrapping up the first hour of the Breakfast Roundtable. We've got news up next.
Edison Carr, Jessie May Venture, and Dr. Wayne Haywood on the Breakfast Roundtable on Sky 99.5 FM. 9.5.